It is the voice of Indiana County, WCCS 101.1 FM and AM 1160. And it is time now for our martial law segment where we talk with Marshal Chriswell. But we do have this to say first. This radio program is intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending upon the date and your particular legal problem. Each legal problem depends on its own individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. With that out of the way, let's bring up on the phone Marshal Chriswell, joining us today here on Indiana in the Morning. Good morning, Marshal.
Good morning, Josh.
I got to tell you, on a personal note, we do miss those trivia nights. I will say that. But
yeah, we do. I know you had some Zoom trivia that you did, but I miss sitting down in person, and that was a lot of fun.
Yeah, we do miss those, but we are getting a little bit off track. But because you wanted to talk about wills on this segment of martial law.
Well, yeah, August, and we've been doing this martial law for several years now, and every August we do have a special focus on wills because August is National Make-A-Will Month. So, in preparation for today, I was looking at some statistics. There's a nonprofit organization called Caring.com, and they every 2 years they perform a survey with regard to estate planning and how many people have wills and things like that. So it's really interesting that in 2017, when they did this study, over 40% of the people that responded said that they did have at least one estate planning document, usually a will. So over 40%, which means that almost 60% of people don't.
Mm-hmm.
But in the subsequent years, in 2019, that dropped down just below 40%. And in this year's survey, only 32.5% of people that responded said that they have a will. So I don't know if we're seeing a trend of people not taking care of these issues. But in any case, those numbers show that so many people haven't taken the step to at least have a basic will in place.
I guess it sounds like there may be some sort of stigma then attached to the idea of having a will in place or having something at least ready to go. And what's when should people have a will in place? So
it's interesting. You mentioned why people don't have a will in place, and this study says that most people, over 40% of the people that haven't had it done, say it's just because they haven't gotten around to it.
Oh, really?
They intend to have a full intention, and also the numbers show that over 30% of these respondents say a responsible person should have a will in place by the time they're 35 years old. That's what many people believe. They realize it's important to do it. It's important to do it when you're young, but they just haven't. And to answer your question, I don't see that many young people in my office creating wills. But whenever you get that first good job,
mm-hmm.
you buy a house. Certainly, when you have children, and you need to start thinking about planning for what happens if I'm not around to take care of my minor child. What do I, putting a guardianship in place for them as part of a will. So, those life events really should lead one to start thinking about getting their affairs in order.
And the big thing is, whenever you're saying creating a will or putting one in place, it sounds like that once you put it down on paper, it is a permanent thing. That thing can be changed by you up until the moment of your death.
Absolutely. Almost all estate planning documents that we prepare, whether it be a will, a living trust, a financial or health care power of attorney, guardianship forms, nearly everything is revocable, meaning that you can come back and modify it, change it, tear it up, completely completely new provisions in, change your beneficiaries, change your appointed executors and agents under the power of attorney. All that stuff can be changed. And most folks that do take these steps and put a will and estate planning documents in place, they do go through several iterations over their life, right? You've got one, maybe some very simple planning done whenever you have that first child, and then you become a little more established later on in life, and you have multiple children or other folks, loved ones that you think, well, I want to arrange things so that they're taken care of, and so generally, we do go through a few modifications of a will during a person's life.
What are some of the benefits of having a legal representation or an attorney like yourself putting together a will versus doing it on your own or through some sort of app?
Sure. So you can, of course, there are websites that offer will and other estate planning documents. These are essentially forms that they are not. The biggest problem with the do-it-yourself wills online, number one, they're usually not state-specific, so you have conflicts with state law that cause a problem. They don't honor the particular formalities for signing and things that you would need to have pursuant to in the here Pennsylvania law. And they are not tailored at all to fit your situation. I can't tell you how many folks I have had come into my office with either a form that they've printed out from the internet and just filled in the blanks by hand, or they've gone to one of the websites that will print out, they will give you the full printed form for you to sign, but they bring that in and they say, all right, well, I did this, it was real cheap, and I just want you to take a look at it and tell me if it looks okay. Mm-hmm. And of course, I always offer a free estate plan consultation, and that's one of the things I'll do is review your previous documents and let you know what we need to do to update them, if anything. And in looking at these pre-printed forms or the fill-in-the-blank forms, 99.9% of the time, after speaking with the client and looking at these forms, we realize that they're not going to meet their goals.
So it would be better in those cases, because you have the fact that you can talk with the client one-on-one, find out what their needs are specifically. That's probably the best reason to seek out an attorney in this case.
Right, and you've also got someone to call if you have questions later, right? I often field questions after I've prepared an estate plan, we've signed everything. Somebody goes home and they have a question about, well, what happens if I become incapacitated and my agent has to use this power of attorney form, or what they start looking at the will again and they think, well, what does this provision really mean? And with regard to inheritance tax or some other issue, and then they pick up the phone and call, and so I'm always available to talk to my clients about those issues. And whenever you go online and print out a form or use an online service, you're not going to get that.
Mm-hmm. We're talking with Marshall Chriswell in our Martial Law segment here on Indiana in the Morning on WCCS, and this is National Make a Will Month, and we're talking about some of the things that have prevented people from getting a will, some of the problems they might encounter if they try to do this on their own. Marshall, what are some of the things that people should keep in mind as far as requirements go? Do you need to have like a specific amount of property, like X amount of dollars of property, in order to put together a will?
No, not at all. It's interesting in this survey, the second highest ranked reason for someone not having a will is because they believe that they don't have enough assets to worry about it. I can tell you from experience, not only do I do estate planning, but I also handle estates after someone has passed away. Mm-hmm. And I can tell you that there are estates with very minimal assets that actually become more complicated than large estates with substantial amounts of assets. There's just as much of the family issues and sometimes the conflict that can arise. And just because you live in a house that's not worth very much, or you have a small bank account and a little bit of tangible personal property, stuff, just because you're of modest means doesn't mean that you shouldn't plan.
Mm-hmm.
There are many reasons to have a will in place, and none of them are tied to what your net worth is.
You mentioned actually, the two biggest reasons why people have not gone ahead and had a will made out. One of them being they just haven't gotten around to it. The other being they feel they don't have enough to justify having a will. What are some of the other common causes that have popped up in this survey that you found?
Another one. So those were the two major ones,
mm-hmm.
and the next one far behind that is I don't know how to get a will or an estate plan. So there are people out there that just wouldn't even know where to begin whenever you ask them that question, do you have a will? And the answer to that is obviously, seek out a lawyer that you feel comfortable with. Like I said, I offer free consultations for this type of work, and make an appointment and go in. And I think another thing is that folks feel like, the people that have put it off feel like they don't have a lot of times enough information gathered. If they say, well, I just haven't gotten around to it, I think a lot of times the underlying issue is they feel like they don't have, we need bank statements and the deed to the house and a copy of our mortgage.
Yeah.
And all our life insurance policies and all these documents, and that's just not the case. Anything to get the process started. So schedule an appointment, meet with a lawyer, and just talk it out, and have a general idea of I have some bank accounts and life insurance policies, and maybe generally what they're worth. But you don't need to drag in a whole briefcase of documents.
That's a relief. You can, if you need those documents, you can go back and find them and then present them to whomever's preparing the will in this case, it sounds like.
Exactly. And a lot of times, right, I have a consultation with a client, and they leave with, a list of things that they need to think about, and maybe documents that they should get and bring back to our next meeting. But I wouldn't ever want that. The feeling that you don't have enough documents or enough information to be a hindrance for someone to put these documents, will in place.
Mm-hmm. Now, how can somebody get a hold of you and your group to possibly get the ball rolling on a will or an estate plan?
Sure. You can always stop in and see us. We're in the R&P building on Church Street in Indiana. You can give me a call at 724-465-5826. Or go online to www.westernpalawyer.com.
Marshall Chriswell, thank you very much for joining us again here on Indiana in the Morning, and I'm sure that we'll probably have another discussion later this month when it comes to wills. But again, thanks for joining us. This was very interesting.
Oh, thank you very much, Josh. Have a great week.
You too. And that was Marshall Chriswell joining us this morning to talk about wills as part of his Marshall Law segment here on Indiana in the Morning. Our interview is presented by Marcus & Mack, a law firm representing injured people.